Hello, welcome to our next lecture. This is Schenck v. United States. We'll actually get into a couple other cases after we delve into this one, but this is another First Amendment issue of freedom of speech, looking at the question of whether certain types of speech are protected by the First Amendment, and what instances and what kind of context are other types of speeches not protected. So, as it turns out, like we've touched on from the very beginning, when we got into this class, the food outside the kitchen, right? It depends on context. Context makes a big difference. So, even though the First Amendment could say that Congress shall make no law respecting establishment of religion or prohibiting free exercise thereof or abridging the freedom of speech or of the press, it turns out speech and press have very unique meanings when situated in a given context. So, Schenck versus United States, the law that we're going to primarily be looking at is the Espionage Act. It essentially outlawed any sort of interference with the government's proceedings with foreign affairs. So, it includes a lot of details, but for our purposes, we need to know that it was illegal to basically advocate against the United States and interfere and obstruct with the draft process there. The Conscription Act is another one we'll get into. So basically, any kind of conspiracy to violate the Espionage Act, whether that was obstructing their recruiting or enlistment services, or any kind of insubordination with regard to those types of things, was a crime. So again, we're dealing with a criminal case here. It's why the United States is a party. They are prosecuting Mr. Schenck against or for certain acts that he committed. So who is Mr. Schenck? He was pretty high up in the Socialist Party. I believe the case said he was the general secretary. And he basically coordinated and resolved to distribute about 15,000 leaflets, pamphlets, informational packets, basically saying how terrible the draft was and is at that time and what men could do about it to basically stand up for their rights. So that pamphlet was ultimately supposed to provide information to these men. The document in question, you'll see here upon its first printed side, recited the first section of the 13th Amendment and said that the idea embodied in it was violated by the Conscription Act. And a conscript is little better than a convict. So, Conscription Act established the first national draft system and required registration by every male citizen and immigrant who had applied for citizenship between the ages of 20 and 45. So, Socialist Party, they're basically saying, look, this draft thing that the United States government has going on to send men against really their own free will into war, not good, not cool. We don't like it. We don't like it so much that we are putting together information. We're putting together packets of information to distribute to men within this age range in certain category. Again, citizens or at least immigrants that applied for citizenship and between the ages of 20 and 45. So they decided to send these pamphlets, create the pamphlets and send out these pamphlets, about 15,000 of them, to inform, perhaps, or educate, or otherwise incite or cause action to take place with these men to stand up for their rights. Assert your rights is one of the things it said, and pointed out the monstrosity. I forgot what the words actually were. The monstrosity or something to that effect. The wrongs committed were so egregious that the government was committing against its own citizens that the pamphlets, and Mr. Schenck in particular, was advocating for protest, basically peaceful protest to be sure, but protest withholding or withdrawing one's name from the draft. I mean, anything to do to basically get guys to stop entering into this draft. So real quick, 13th Amendment, we touched on that, of course, in the end of the Dred Scott lecture. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So the basic argument of the pamphlet, right, is you're forcing guys into involuntary servitude by forcing them into the draft and go serve in the military or go fight across the seas. And so this was a way to get education out there, right, to advocate and ultimately undermine the draft process. So Mr. Schenck, I believe some other people perhaps, but Mr. Schenck is who we're going to focus on. He is convicted under this Espionage Act, right? He's obstructing the draft process. He is conspiring and inciting certain behavior in people. And so the court has to look at this and say, okay, well, that's interesting. I conclude here, we do not see what effect it could be expected to have upon persons subject to the draft except to influence them to obstruct the carrying out of it. Right? Very important. The defendants do not deny that the jury might find against them on this point. So, very similar to our last case, Reynolds v. United States. There was a law, and by golly, Mr. Reynolds violated that law. He really didn't protest that. What was his defense, right? What was his argument? That the law itself was unconstitutional. Same, or at least similar here. It's not so much that they didn't violate the law. It's more that the law was unconstitutional. And so going back to Marbury v. Madison, if a law is unconstitutional, right, the Constitution is going to take priority and precedent over any other federal law or any other law, state law for that matter, that we'll see here in a bit with the other case. So if the law itself is unconstitutional, then we'll throw it out, right? It violates freedom of speech. Again, going back to the First Amendment, Congress shall make no law abridging the freedom of speech or of the press. So here's a pretty good example, right? These guys, the Socialist Party, have a certain understanding of the way that the government should act, the way that they should promulgate laws, the way that they should treat their citizens. The 13th Amendment is even thrown in there as far as supporting their position. So it's not just burn the whole building down. It's at least saying, hey, the 13th Amendment says no involuntary servitude. So their position is you forcing guys into the draft to go serve in the armed forces is involuntary servitude. And by virtue of creating involuntary servitude, the United States is actually violating a person's rights that are protected by the 13th Amendment. Okay, that seems fair enough, but by virtue of inciting this sort of behavior, right, to obstruct the carrying out of the draft, then it violates the Espionage Act. And so that is now the heart of the case. The issue is now whether this speech, this pamphlet, is protected by the First Amendment. So it's okay to basically have competing ideas. It's okay to say, on the one hand, we need guys to serve in the armed forces, and we want to have policy that's centered around that belief. And it's another thing to say, absolutely not. It should be completely voluntary. There should be no forced draft, and there should be no involuntary servitude as provided by the 13th Amendment. There is that clash of ideas there. And so the fact that Mr. Schenck went ahead and distributed these 15,000 leaflets to men that it would pertain to between the ages of 20 and 45 citizens of the United States, then that is now the issue that the court has to deal with, is whether this speech is protected by the First Amendment. Because as soon as it's protected by the First Amendment, then the Espionage Act would be considered unconstitutional, at least for that pretty narrow provision within the act. So, what does the court say? We admit that in many places and in ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends upon the circumstances in which it is done. Pause. Let me put a pause right there. These blue things, blue hyperlinks, if you've clicked on them, they'll take you to cases. I don't know if I've brought this up before, but this is a point, sort of housekeeping item. These are the cases that the court is citing as precedent for these general claims. So at this point in time, the country is now a little bit more underway. We're now in the 20th century. There's been case law. There's been all sorts of cases gone through a variety of courts and the Supreme Court. So there's precedent now. There's a body of case law that has been promulgated by the United States Supreme Court. So anytime there's kind of these bold claims like the character of every act depends upon the circumstances in which it is done, if that sentence sort of flags out in your mind of like, wait a second, where did that come from? It certainly wasn't the Constitution. Where did it come from? More times than not, I'm not going to say every time, but more times than not, there should be this citation here as far as where they pulled that rule or that concept, that foundation, that principle of law there. So we don't necessarily need to go down the rabbit trail. I am very scholarly at times, which is a polite way of saying I get lost in the weeds. So more times than not, when I was in law school, I'd love to be able to trace this history of the case, right? To figure out where did they get this claim? Where did this come from? It wasn't just a argument that they necessarily put together to conclude. That's largely what we saw in Marbury v. Madison. But it's now to the point in our history, right, the history of constitutional law, that there are existing cases out there that would support general claims or conclusions or principles or holdings of law. Now, when the court is weaving together an argument, it's not to say that that exact structure, right, the exact rhetoric has been used before, but perhaps general claims like it depends on the character of the act, it depends on the character of every act depends upon the circumstances of said act, then that may be a principle that was already used or at least created or discovered or whatever else it may be in a given act. So like Akins v. Wisconsin, I don't know. I'll be honest. I don't know what that case necessarily says or talks about. But when I'm doing research, even in my current practice, especially if it's a very finely tuned point, I do want to trace back where this actually came from to make sure it's good law. So let me went off on that tangent, right? Went on that rabbit trail, coming back now to the court actually stating this somewhat unique proposition here. So again, speech protected by the First Amendment. Yep, they're going to admit that's usually true. But the character of every act depends upon the circumstances in which it was done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic. Very well-known example. This is Justice Holmes writing this opinion. Justice Holmes is a very well-known scholar. He wrote this book called The Common Law. If you are interested in these kind of things, it may be another class that we go through. We may actually just go through this book to truly have an appreciation for the common law. His legal theory, though, it's probably not the well, it's worth diving into. I don't need to go on that tangent. Let me just park that in your mind. That's who we're dealing with here, Justice Holmes, because you'll see here in a second too the dissent that he writes in another opinion. So this example he gives is basically, look, if you're in a crowded area and all of a sudden you falsely shout fire, right? There's not a fire anywhere. There's not a reason to cause panic. Then that's not going to be protected by freedom of speech. It's not be protected by the First Amendment. That seems to be made up, right? That example, but it seems to also touch on a certain principle of, yeah, that kind of makes sense, right? There's sort of a common sense element here that you can't just say whatever you want to, okay? You may have the protections and the freedom of speech and press, but when we're looking at a context, right, when we're looking at a situation in which words are being said, words have meaning, okay? Words have impact, and they can, in fact, influence and cause and incite behavior in other people. Okay, fair enough, right? Think about any time you went to a speech or a concert or, any number of the last, gathering of people even. When someone says something like stand up, right? People stand up, or when there is something funny said, people laugh. End of a performance, people clap. Right? There is something about the nature of communication such that when words are said, actions are somehow incited or otherwise caused. So this concept of, yep, you got freedom of speech unless you don't, that we're okay with that right now. That's not to say that Constitution just protects any form of speech. And that's what Justice Holmes gets to at this point, is that, yes, in ordinary times, ordinary places, sure, these people, Mr. Schenck, could in fact have his opinion, distribute his opinion, talk about his opinion. No big deal. But the character of every act depends upon the circumstances in which it is done. So, for example, if I was to shout, "Fire!" right now, you can't really see my entire camera, I suppose, but I'm not in a crowded theater, nor did I really shout in a way that would cause any sort of panic. My wife is downstairs, for example. My oldest son is napping in the next room. Now, if I was to shout as though something was terribly wrong, I'm not going to do that right now, but I could almost guarantee you that my wife would come running up the stairs, right? My child would wake up, perhaps in a fit or otherwise, because something about the way I communicated a given word, even like fire or help or any number of words, would cause panic. And so that's what the court's looking at now as just an example of, yeah, words are important. So you can't just say any words in any given context. It really depends on those circumstances in which those words are said. So what kind of rule is the court going to look at here for this case, for Mr. Schenck in particular? The question in every case is whether the words used are used in circumstances and are of such a nature as to create a clear and present danger, that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. When a nation is at war, many things that might be said in time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. Okay, so what sort of circumstances are we looking at here? The United States is at war, so that changes things all of a sudden. That's sort of contrived and created out of thin air, supposedly, of, you know what? Not everything can be said at any point in time. Perhaps saying things like, assert your rights and don't enter the draft would be perfectly fine if we weren't at war. But since the United States is at war, we need men to go fight, and we need men to be in battle. And so we do want, as a nation and as a policy procedure, the law to recognize such a difference. So we're at peace as a country. Yeah, no problem, perhaps, of arguing whether the draft is constitutional. We're actually at war, and we need men to go fight and stand up and defend our country. Yeah, we want that to happen. So this whole stand up for your rights and obstruct and inhibit the draft, we're not going to protect that speech. The law is not going to protect that speech. Again, that's the foundational principle from Marbury v. Madison. The court is supposed to say what the law is. And so in this case, the court is drawing a distinction between freedom of speech, depending on the circumstance, and in this particular case, we have war and peace. So if you're at war, certain things are not going to fly, right? We're just not going to be able to say things like, don't enter the draft. Not going to be protected. Why? It's going to cause the substantive evils that Congress has a right to protect, namely through the Espionage Act. So, with that being said, whether speech is protected depends on whether the words are used in such circumstances and are of such nature as to create a clear and present danger. That's the test. That's now the rule that the court is going to follow and look after. So if a given act of speech, utterance, any kind of communication, press, words typed up, distributed, whatever else it may be, creates a clear and present danger, then That's it. It's not going to be protected by the First Amendment. So in other words, if anyone at any point in time is going to create a clear and present danger by what they say, what they utter, communicate, put any kind of verb that you can think of in that context in that blank, if it creates that clear and present danger, the First Amendment is not going to protect that speech. That's the rule that we get from Schenck v. United States. Okay, so context is everything. That's the other kind of big theme to pull out of this. If we're at war, those rights decrease. If we're at peace, those rights increase. What can be said depends on when those things are said. If the things said create a clear and present danger, again, this is now a term of art. We've touched on that before. So seeing that phrase is now going to be extrapolated and used really throughout the next several years and decades of cases, but we don't need to focus on that right now. Just know that if speech causes a clear and present danger, then the First Amendment will not protect that speech. Awesome. So, it just so happens that a few months later, we get a nearly identical case in Abrams v. United States. I don't have the entire majority opinion on here. Only thing we really need to know is that basically the United States is in Russia. They are fighting Germans. I think it's after the Russian Revolution, and defendants are convicted for 2 leaflets of information that they had thrown from a New York City window, where they basically denounce American troops being in Russia and advocated for the strike on ammunition factories. So like people working at the ammunition factories, stop what you're doing. It's causing bad things to happen. And it's almost the same exact scenario here. We're dealing with the Espionage Act again. The defendants are undermining the U.S. efforts to fight in this skirmish or in this war, this military operation. So the fact that these pamphlets are advocating for the obstruction of the United States efforts in this military operation is pretty much an open and shut case, right? We just saw it with Mr. Schenck. The United States federal government wants men to be drafted so they can go fight. They're in the middle of war. This is a few months later. I think Schenck is in March, and now this one's in November of 1919. So, I mean, literally within the same year. What happens, though, is that these fact patterns are running in parallel. So Schenck's decided we got clear and present danger. If speech causes clear and present danger, it's not protected, can't do it. So the law is going to stand and the people's conviction are going to get upheld. Same sort of question here. The amendments to the Espionage Act, or the application of those amendments in this case, violate the free speech clause of the First Amendment. Courts got a pretty easy day. They look at this and say, okay, these pamphlets, they're basically advocating against the United States. Military operation is going on, and these pamphlets are saying, don't do it, right? Don't do it. We don't want them to be there. They're being perhaps adversarial, or at least in opposition to. And ultimately, they're causing and advocating for the cessation of the production of weapons. They're saying, hey, workers at the ammunition factories, go on strike. I think they were in English and Yiddish as well, 2 pamphlets. But anyway, they're basically the same facts. The United States federal government and its military operations are ongoing. People, in both cases, have circulated pamphlets that basically advocate against those military operations. So in Schenck, they said, can't do that. Creates a clear and present danger that men would basically stop going to the draft or what else it may be, cause a riot, or otherwise undermine the United States military operations and clear violation of the Espionage Act. Here, same thing. If they're advocating that workers stop working in the ammunition factory, then ammunition can't be sent over to Russia. It thereby undermines the United States efforts in their military operation. Same thing. So the majority has no issue with this. It's a 7-2 opinion. And so, take any guesses as to who was the dissenter here, who dissented? Yeah, it was Justice Holmes. So, I mean, it's the same sort of, straight up and down facts are very, very similar. The fact that the Supreme Court would hear both of these cases within the same year is also somewhat surprising. Sometimes they group these sort of cases together if they're on the same sort of fact pattern. But anyway, so Justice Holmes dissents. And okay, so I kind of, we look around like, what are you talking about, Holmes? Like you just said, and you wrote the majority opinion in Schenck, right? Holmes delivered the opinion, and so now you're dissenting, and what's the deal here? So, his dissent basically points to the protections of speech should not be curtailed unless the present danger of immediate evil, and also you have to have a pretty serious intent to cause the thing. So all of a sudden it's not just a clear and present danger. So it's not just fire in a crowded audience, and of course that's going to probably cause a panic and a danger, because who else screams fire in a crowded area unless there's a fire and we need people to get out of there so they don't become injured or otherwise. So Holmes goes through this analysis and basically expands his thinking as to when speech is not protected. So he kind of, instead of draw the line closer to the First Amendment, which would be more along the lines of the Espionage Act, actually kind of pushes it further away and kind of gives more ground for the First Amendment protection. Let's see. So this is a pretty good example here. A patriot might think that we were wasting money on airplanes or making a cannon of a certain kind that we needed, or need to make more of a cannon of a certain kind that we needed, and might advocate curtailment with success. Yet even if it turned out that the curtailment hindered and was thought by other minds to have been obviously likely to hinder the United States in the prosecution of the war, no one would hold such conduct a crime. So the power undoubtedly is greater in time of war than time of peace, but war opens dangers that do not exist at other times. So real quick here, we're looking now at the scope of what was done. So his example here is kind of, I think he says too, does not answer all the questions that might be said, but he sort of couches now this context of, it's dependent on the circumstances, right? Are we in war? Or are we at peace? I just said this a few months ago. Are we at war? Or are we at peace? It depends. When we're at war, the rights protected by the First Amendment actually decrease. Why? Country at war, we need to get everyone on board. We need to fight that war, etc. So when we're at peace, then those rights actually increase, right? We're at peace. Like, okay, you can say what you want to say. If you disagree, you disagree. So here's, for example, a good law-abiding citizen, right? A patriot may think that, the government's wasting too much money on airplanes. Or, we need a different kind of cannon. Does that undermine the efforts? Perhaps, right? We could say that this guy needs to just blindly follow whatever the United States government is doing and just say, yep, that's the right thing. Why? Because it's the United States doing it. Kind of that circular reasoning there of, or begs the question, right? The United States can do no harm, essentially. So whatever the United States does is right. And so, okay, that's one example, but it's sort of small peanuts, right? Like, who cares? It's one guy. It's just doing one thing. And then he kind of touches on this whole concept of, the power. I know I talked about the war and peace and all that kind of stuff, but now there's a danger that certain rights will be infringed upon. So he says, but as against dangers peculiar to war, as against others, the principle of the right to free speech is always the same. It is only the present danger of immediate evil or an intent to bring it about that warrants Congress and setting a limit to the expression of opinion where private rights are not concerned. Okay. So we have his whole opinion here in the Schenck case saying if it's a clear and present danger, that's where we're going to draw the line. Now, just a few months later, he's looking at the same sort of facts. Again, there's a couple people, they disagree with the United States involvement in Russia pertaining to certain military operations. And so they distribute literature, 2 pamphlets that say, basically, we don't like what you're doing there, United States, and workers in these ammunition factories, you should go on strike. You should stop making ammunition so the United States doesn't have it to send over there. That would seem like a clear and present danger, right? How it's actually connected, the majority opinion will get into that. We don't need to go into it here. But just looking at a one man, right, Justice Holmes, good old Justice Holmes, can go from a few months ago saying, yep, just a clear and present danger, depends on whether we're at war or at peace, to, actually, you know what, it actually matters more about whether there's immediate evil or an intent to bring it about, because certain rights can be infringed in the name of war. Okay, so now we're in kind of an interesting position. This is a dissent, so it's not law. It's not. It can be persuasive at times, depending on the holding of the majority opinion versus what the dissent is actually getting into. But it's still Justice Holmes, huge figure in American jurisprudence. So this opinion, this dissent is analyzed. There's a lot of scholarship regarding this distinction between, on the one hand, we have the clear and present danger, and now under similar facts, we're going to look at more of the scope of the situation and see if there's immediate evil and if there's an intent to cause that evil. Okay, so what we're looking at here, he points out real quick too that this probably has more to do with their beliefs, right? Their creed, their anti-United States stand than their actual conduct. Why? Because we're talking about 2 pamphlets here. Again, going back to the patriot that is criticizing the airplanes. You know, if he's having coffee, or if he's at the factory with buddies or whatever else may be, and he scoffs at, we're just making too many airplanes, or we're using the wrong kind of weapons, and his buddies all kind of scoff and agree. You know, does that violate the Espionage Act? Do they just intend to undermine the United States war efforts? Probably not, right? He's just one guy, and he's just kind of in his own little club. He's not trying to distribute perhaps 15,000 pamphlets advocating for a riot or insubordination or obstructing the draft process. It's small in scope. Okay, speaking of yelling fire, oldest son woke up, got him situated, so we're back. If you'll forgive me, I lost my train of thought. So I believe we were talking about, let's see. So we're basically talking about what's the nature of these pamphlets, right? What's the nature of this speech? So we understand now that speech has an effect on people. It depends on the circumstances, right? If we're at war, if we're at peace. And Schenck, it was the clear and present danger. If speech is causing a clear and present danger by virtue of what is being said, again, fire in a crowded theater, even though there's no fire, then no, there's no protection there. There's no First Amendment protection. So Holmes here in this dissent seems now to be expanding his earlier claim, right? His earlier conclusion that it depends on the clear and present danger. He now says that the principles of the right to free speech is always the same. It is only the present danger of immediate evil or an intent to bring that about. So, with regard to this case in particular, it's 2 pamphlets. 2 pamphlets of information. Is it contrary to U.S. foreign policy? Sure. Is it creating an immediate evil? No. Holmes says it's not. It's not creating an immediate evil. There's no reason to prosecute and ultimately uphold this conviction of these people. They have the First Amendment, and they're not creating any kind of immediate evil. Again, he's not thinking along the lines of clear and present danger anymore. The majority does. How they arrive to that conclusion is perhaps worth digging into, but like I mentioned earlier, it's basically the same fact pattern of Schenck. You have people that are generally disagreeing with U.S. policy. There's law in place that says don't disagree with U.S. policy, especially in times of wars, what the court looks to as well. So open and shut. It's a clear and present danger. Same thing here. Even though it was only 2 pamphlets, they were creating that clear and present danger. That's it. Holmes, though, in his dissent, again, takes this a little bit further. And he says, persecution for the expression of opinions seems to me perfectly logical. Okay, we covered that in the Reynolds case as well. There's a difference between religious opinions and beliefs, and there's a difference between, there's a difference between religious opinions and religious actions, or actions promulgated by those opinions. So you can believe what you want to believe. When you start acting on those beliefs, that's where the government, the legislature, can come in and start protecting that line. So same thing here. Holmes is looking at it and saying, you know what, freedom of speech, we like that concept, but it is only a present danger of the immediate evil or an intent to bring it about that warrants Congress in setting a limit to the expression of opinion where private rights are not concerned. Okay, so Congress has its area. It has its ability to look at when speech would cause evil, present, immediate evil, and if people have the intent to, so it may not actually cause it, but if they have the intent to cause it, then Congress can definitely step in and legislate accordingly. So persecution of the expression of opinion seems to me perfectly logical if you have no doubt of your premises or of your power and want a certain result with all your heart. You naturally express your wishes in law and sweep away all opposition. To allow opposition by speech seems to indicate that you think speech impotent, as when a man says that he has squared the circle, or that you do not care wholeheartedly for the result, or that you doubt either your power or your premises. So if you know what you're talking about and you like what you're saying, and you have that power to keep saying it, then who cares that someone would challenge you, right? It doesn't matter that there's a certain pushback or opposition there. So that speech should be allowed. In other words, like it's okay to have competing opinions. It's okay to have disagreement, especially if you are secure and confident in your position. So the persecution for the expression of opinions seems to me perfectly logical. If you're confident with your position, then who cares what anyone else would say? But when men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted in the competition of the market. And that truth is the only ground upon which their wishes safely can be carried out. Very important, very dangerous concept here. That truth is somehow predicated on market supply and demand. That's the analogy he's drawing out here. I think it's an ideal opinion here. I think I have some time to wrestle with this concept, but he's essentially thinking about this as though there are ideas that can compete with one another, right? There can be debate back and forth, and whichever one shows itself stronger must be the truth, right? Whichever one is accepted in the marketplace of ideas is the truth. So if you have competing notions of the good, for example, and you say the good is X, well, no, the good is Y, and that is circulated around, and everyone has the freedom to express their given opinion about X or Y, then within that marketplace of ideas, the market will decide what is truth. I don't think that's right. I don't think that's what truth is. I don't think that truth is predicated on our beliefs or the ability to debate ideas back and forth. I think if that is the way we approach things, then might perhaps does make right. And whoever gets retweeted the most or has the most posts shared or what kind of information is circulated in the news syndicate is true. I would say that is not the way that we approach this, right? I don't say that this is a way that Christians look at truth. I don't think that's the way that we approach truth. I think truth is truly universal, right? We know that God is truth. We know that Jesus promulgated himself, responded to saying that he is truth, right? He is the way. He is the truth. He is the light. Like that sort of aspect of our Christian faith would lend us to believe that when it comes to more or less philosophical debates, or in this case, legal debates, there may very well be competing notions of what is true or what is good. But the fact that it would exist in a marketplace and the market decides, right, the people decide what is true, ultimately undermines anything we could believe about truth, right? All of a sudden, it's not so much subjective. It would almost be whimsical. It'd almost be an ebb and flow of the truth for that day, depending on what the market is. So if the market's up on, whatever it may be, X, then, okay, X is true. But if the market's down on it, right, and it has more of the bearish market, then no, all of a sudden Y is true, or whatever it may be, right? You can kind of see the analogy there. But this is kind of the whole reason, though, that Holmes' dissent points out that, look, we want people to be able to talk about things that they don't necessarily agree upon. We have this marketplace of ideas. So if you're confident in your position, then who cares what your opposition is going to say? It's ultimately going to be the competition of the market that determines the truth, whatever that may be. But as far as certain kinds of speech that would incite certain behavior, that would incite certain evil, okay, cool, fine. No protection there. Congress can step in and regulate accordingly. But we're going to broaden the scope in Justice Holmes' opinion, because he is believing, perhaps ideally so. I don't think he's being stupid here. I don't think he's being ignorant. I think he truly believes that if all men could, sit around and have these kind of conversations with, a nice little coat and tie and, read the law books and read all the arguments and, ponder truth, then that could very well be what the marketplace of ideas is. So kind of in other words, if Justice Holmes could have anticipated Twitter or any kind of social media, I wonder, and I don't know this, but I wonder if he would say the same thing, right? If in his mind it's all well-educated men that are similarly situated with regard to their upbringing, to the books they read, to the languages they studied, to their law practice, and then those are the ones that get to discuss the ideas, the competing notions of the good, the true, the beautiful, then maybe that does sound ideal. Maybe that does sound good in kind of a shallow sort of way. If we're predicating truth on majority opinion, then I would think that ceases to be truth. I would think that just becomes majority opinion. So this concept, we're going to see play out several times over. This is another really important paragraph within constitutional law, this concept of marketplace of ideas. But all it to say is, zooming back out, we have the Schenck case. Schenck case has guys that are basically protesting, advocating for the obstruction of United States foreign policy. The law in place, the Espionage Act, says, not going to happen. Can't do it. It's crime. Defendant's going to say, wait a second, I have First Amendment protection. Court's going to say, no, you don't. It depends on circumstance. We're in war. Your rights are decreased, and this is creating a clear and present danger. Fast forward a few months later, we get to the Abrams case. Very similar fact pattern, except there's less pamphlets, so arguably less scope, less impact on the United States foreign policy or any kind of obstruction there too. And majority opinion looks at itself from a few months back. It says, okay, clear and present danger, sure, lock them up, throw away the key. Holmes, though, who wrote the majority opinion, is now writing a dissenting opinion and says, you know what, actually this whole concept of freedom of speech, we actually need to push those boundaries. We need to make the boundary for the freedom of speech broader. We need to have more freedom given rather than take more or take it away. So it really only depends on the immediate evil and intent to bring it about that warrants Congress to make certain laws. And so then this concept that we just talked about too, we want people competing in the marketplace of ideas for what they believe is best. So if you want to protest the United States involvement in Russia and want to advocate for people to stop working at their jobs in the ammunition factory, we as a society should be able to reconcile those competing notions rather than follow blindly a government that has and is enacting foreign policy in Russia or Germany, where else it may be. I think there's some element of truth to that, but is that where truth is derived from, right? Is that the concept of truth? No, right? We'll push back on that in our reflection questions. Hopefully, be able to wrestle with that a little bit more. Of what does he mean here? When you get through the case and you're able to read this dissenting opinion, what does he actually mean here? So, those are Schenck and Abrams. To now put a bow on it, we're going to get to the Brandenburg v. Ohio case. So, Brandenburg v. Ohio, Ohio state law basically said, look, terrorism, any sort of speech advocating for crime or sabotage or violence, it's a crime. No, I'm not going to allow that to happen. We don't want our citizens advocating for crime. We don't want someone to get up there and say, let's go hurt people. Or we don't want encouragement of terrorism. We don't want people, saying or demonstrating or otherwise influencing other people to cause mass riots and burn down buildings. We don't want that to happen. That's not what a well-functioning society does. So, facts of the case then, we have Brandenburg, who is a leader in the KKK, at a rally doing what folks at KKK rallies do, advocating for terrorism and violence and sabotage. So he's arrested and he's charged under this law, this criminal syndicate. You can't create a criminal syndicate, right? You can't promulgate that. And he's charged and he's convicted, and so he appeals it all the way up to the Supreme Court, claiming, wait a second, I got First Amendment rights here. What does the court do? The court throws out the book, basically. So the whole clear and present danger test, any kind of notions that are remnants left over in the Abrams case, we're going to throw that out. So the Brandenburg case is more or less, I'm not going to say it is a law, but it's more or less the analysis we have now, the Brandenburg test, or the imminent lawless test. And so they're going to look at whether speech is directed at inciting or producing imminent lawless action, and 2, is it likely to incite or produce such action? That's sort of the test it's operating now. So someone can say something, that's fine. We're not going to prohibit it. But if it's directed at inciting or producing imminent, so right then and there, lawless action, and there's a high likelihood of such action, then yeah, that's not going to fly. We're not going to have First Amendment protection for that kind of speech. So, like I said, overturned Schenck and Abrams. The court in this case ultimately held that the Ohio law was overly broad. So it's not to say that the Brandenburg actions were like good, right, or just, or ought to be in any way repeated. But they were looking at the law and they said, okay, if you're going to limit a person's speech in this way, it's just too broad. So this Ohio law has to be struck down, and you have to basically operate now under this new test, this imminent lawless action test. So if the speech is intended to incite imminent lawless action and it's likely that action will occur, then that speech is prohibited. So in other words, if I'm giving a wonderful speech on the foundations of law at a senior adult center and there's no microphone, people can hardly hear me, but I'm screaming, let's burn the house down. Let's burn it down. Imminent lawless action. Is that likely to happen? Probably not, right? Probably, I wouldn't think so. Maybe I'm being prejudiced right now, but I would not think that the seniors are all of a sudden rising up and, setting ablaze all the furniture and puzzles and lunch trays and everything else around them on fire. Probably because they can't hear me, but probably because there's not that sort of immediacy to the action. Now, if there's another circumstance where you're at a concert and the musician is saying the exact same thing, the exact same words, let's burn the place down, and we know that there are illegal drugs and intoxication, and it's late at night, and there are torches and lighters and lighter fluid readily available. Interesting question, right? Interesting question. We're going to look at this test, and that's how we're going to analyze this question of whether that speech would be prohibited. So that's the Brandenburg v. Ohio case. If you're interested, by all means, you can look into it. I just need to go over a quick overview to see more or less where we are now, how we're going to analyze speech. But more importantly, show how Supreme Court can basically go from one opinion to the next opinion and basically change its mind under the same fact pattern. I should really say one justice, but moving forward all the way to Brandenburg case, the Supreme Court ultimately decides, you know what? No, this isn't going to be the test we use. We're going to change it up altogether. So speech is protected by the First Amendment until it's not. When is it not? When, for a variety of reasons, but for now, when that speech is directed at inciting or producing imminent lawless action and is likely to incite or produce such action. So generally, we like when ideas are bounced around. I don't think that the truth is predicated on the marketplace of ideas. I don't think that's what truth is. I don't think that's the right way to look at truth. But to go back to Justice Holmes' dissent in Abrams' opinion, that's sort of his conception is, wait a second, we really need to raise the bar for when speech is going to be prohibited, because otherwise we want people to be able to talk about their different ideas for their conceptions of the good. Going all the way back then to the Schenck case, first time really to come up with this idea of a clear and present danger. So speech is good up to the point where it could cause harm. When it causes harm, we're not going to protect it under the First Amendment. That's that. Any questions, please let me know. This may be a little bit more convoluted because we went through 3 different cases. There is a theme through here, of course, about when speech is protected. But if something didn't make sense, if something in the case isn't clicking, please let me know. Love to answer those questions. Love to help out to hopefully tease apart these concepts within our reflection questions. And otherwise, I will see you maybe next week, maybe in a couple days. But otherwise, before then, pray that you have a blessed week and best of luck with all the other things you got going on. Take care.